Hello everybody, welcome back to the second of our two talks on child protection in Germany. I was, at the end of the last presentation, I was outlining the structure of the SGB Act. This is this big law dating more or less from the same time as the England and Wales Children Act, the late 1980s. This law which really regulates all of the children's services in Germany, essential knowledge for social work students. Typically they'll do a whole module on this in their law courses. So the Sozialgesetzbuch Act. Giving the Children's Services Law in clear and readable detail. The statute is divided into around 105 individual sections. I didn't actually count them, they are numbered, and that's why I say around. When we add amendments into this, the amendments have the number which they relate to with a letter afterwards. So they're inserted in the right place, so to say. And of course, in principle, one of the individual sections might also be removed. So it's only approximately 105. The German word for section is paragraph, but the meaning is the same thing as the Anglo-Saxon section. The sections are grouped collectively, so you get little bundles of sections dealing with similar things. The first 10 sections are giving you general principles. In my last presentation, I referred you to the United Nations Convention on the Rights of the Child. Many of those principles appear in the first 10 general sections of the German Act. And examples of that: equal treatment of boys and girls, participation, freedom of choice. So again, regardless of your nationality, I'm guessing you'll be seeing familiar stuff, particularly in the opening part of this German law. Be good. We have a section on family services. Section 11 to 14 cover youth work. Then we've got a collection of sections covering support for child raising in the family, quite general interventions there. Then we have a bundle of sections concerned with nurseries and preschools. Really interesting. In Germany, these are grouped together with social work services. So they're kind of natural neighbours of social work, and they're not part of the school system as they may be in other countries. Sections 27 to 40 describe forms of German family support, which I find especially interesting, and I'll be talking about those together in two other videos for you guys. Our topic today is child protection. The fundamental principle of German child protection is to be found in the basic law. Hey, let's go back to the Constitution, which we touched upon last time. Can you remember the criteria for intervention against the will of parents? We had in that formulation, in that Article 6, we had a formulation where it was clear that we could intervene in the family life against the will of the parents, but with the history of Germany, with its difficult and dark history, the formulation was very, very precise to really limit this attack on parents' parenting rights. What was that formulation? We had a very strict only if formulation. We can intervene only if the parents or guardians fail in their duties, the German word is versagen here, or if the children are otherwise in danger of serious neglect. Okay, so we've got two criteria. Only if one of those two is the case is the state allowed to intervene against the will of the parents. So basically we have the concept here of the welfare of the child. The state can only intervene to protect the welfare of the child. In German, Kindeswohl. State intervention. The duty of the state to protect, Schutzauftrag we might call it in German, is detailed in section 8a, and you can see the little letter A suggesting a more recent amendment. Now, this explains procedurally how the state intervenes, what the various parties must do at what particular time scale, in what particular order. That's outlined explicitly there. The Children's Department, the Social Services Department, and the Family Courts, they're the key institutions involved in procedures. So, maybe it's fun if I outline what that particular section says in terms of questions. Here's some questions for us to scratch our heads over. I think these questions are the big ones. What must the Children's Department do when they have reason to believe that a child is at risk? You know, what is the procedure when we think that a child is at risk? Is the person with parental responsibility and the child to be involved in this? What should the Children's Department do if it considers the family court should be involved? And what if the persons of parental responsibility, the parents typically, is against this? What must be done in the case of immediate danger when the court's decision cannot be waited for? And again, if you're a German student, of course, this is a nice time to have a look in your law books, have a look in your statute, paragraph 8a, find the answers. But if you're not a German student, relax, I'm now going to give you the answers. How does it work? Children at risk. What must the Children's Department do when they have reason to believe that a child is at risk? The lawmaker tells us this with clarity. Look at this, section 8a, subsection 1, sentence 1 states, if the Children's Department becomes aware of grave indicators for the risk of the welfare of a child, then this risk of danger is to be assessed in collaboration by several professionals. Interesting how, so again, you can get a real insight into the formulation in the legislation here. This is my own translation from the German law. My second question, is the persons of parental responsibility, the parents, and the child to be involved in this? Once again, the legislator is very, very clear. The person with parental responsibility as well as the child are to be involved, as long as this does not impact on the effective protection of the child. So in Germany, we would assume that the parents and the child are to be collectively involved in any kind of actions. It's a very participative form of child protection. The only exception is if this may negatively impact on the protection of that child. So you can think of particular cases where that may be the case. But as a rule, we're involving the parents, we're involving the child. The family court. What should the Children's Department do if it considers the family court should be involved? In other words, to make a care order or a German equivalent thereof. And what if the persons of parental responsibility, is against this? Once again, very, very clear. If the Children's Department considers action from the family court to be required, it is to initiate care proceedings. This is also the case when the person or persons with parental responsibility are unwilling or unable to participate in the risk assessment. So again, the formulation is quite strong. If the social workers feel the family court needs to be involved, thinking of care proceedings, then they have that power. Immediate risk. What must be done in the case of immediate danger when the court's decision cannot be waited for? The law, again, it gives us the answer here. If an immediate risk exists and the family court decision cannot be waited for, I'm guessing, for example, it's in the middle of the night, the Children's Department has a duty to remove the child to a place of safety. So in extreme moments of immediate danger, immediate risk, the Children's Department, the Children and Family Social Worker, has a duty to remove the child to a place of safety. Called in Obhutnahme in German, of course very similar to procedures in other countries. Note in this particular case, in this legal framework, it's the social worker that has that particular emergency power. We've talked about the family courts just now, and that's the logical next step. In those cases when this particular family, this child protection case, goes to the family court, how does it then proceed? Once again, we have to hop over to a different law book. The good news is this is the civil law book, which is actually translated into English. So if you want to investigate this further, you'll find this particular paragraph or section in English on the internet. And it's a strangely numbered section, section 1666, places the duty of the family court to take necessary measures to avert risk. And have a look at this, to avert risk to the physical, intellectual, or mental welfare of the child. Due to what? Due to abuse of parental responsibility, neglect, unintended failure of parents, or the behaviour of third parties. So once again, the lawmaker is being very, very broad here. You know, this is broad legislation, but the detail is quite fascinating. And I was looking at UK or England and Wales social work law. There's a lot of parallels here. You know, when you list explicitly physical, intellectual, and mental welfare, you know, that will have echoes in the formulations in other nations' child protection legislation as well. I'm talking about this. Some of the amendments I've been talking about are very, very young. This really is a current concern in Germany. When I was a social work student, I didn't hear the word child protection so often. It really wasn't so current when I started my studies. That must have been in 2004. But the next few years really saw an increase in interest in this topic. You know, we entered into a child protection discourse. And interestingly, if you look at books in German published with words like child protection of the title, they're often published over something like the last 12 or 13 years. So this really is a kind of a current, very much a 21st century discourse. Rather gloomily, Germans have discovered child protection issues in a heightened sense in recent years. So this is really where we're at right now. Very current concern. Of course, the concern, like in other countries, was triggered by child protection failings, which had a high media profile. So failings stimulated reforms, yeah, just as elsewhere. I've described this paragraph 8a, this amendment from the early 21st century. We had a second one tagged onto that a few years afterwards, the Federal Child Protection Act, and that has various components. One part of that is this Section 8b, which kind of extends many of the ideas in Section 8a and builds on them. Thinking interestingly about similar topics to recent UK-US discourses, the idea, for example, of information sharing, data sharing, and so on, networking agencies, those thoughts. So fascinating parallels if you're following child protection discourses in one country, the case of Germany, it's a really interesting extension, many overlapping discourses, overlapping ideas, and as I've shown today, probably very comparable procedures in Germany to elsewhere. Well, I've hoped you've enjoyed these two presentations. Thanks a lot for listening. Let me come to a close now. Thank you.